Good morning and welcome to today's session. Good morning to the US, good afternoon from Paris, and to all sorts of different participants joining from around the globe. Um, my name is Fiona Mangan. I'm a member of the UN panel of experts on the Central African Republic, but will be joining today in my capacity as the Research Director of Justice and Security and Transitions, and of course, as the co-chair of the ACIL International Organizations Working Group. I'm happy to be joined today by my co-chair, Duncan Picard, and vice chair, Ashwita Ambast. And this today is the first in a series of mini panels that we have set up and intend to host over the next few months. And the idea is to spark discussion around a number of very recent developments involving international organizations. And each of those panels will take a very straightforward and simple framework, the format of a Q&A session with initial questions posed by a moderator, today me, and then move to a set of questions from the group. Today's event is entitled UN Operations in Palestine after the ICJ's 2025 advisory opinion, Implications for Privileges, Immunities and Assistance. We're very pleased to be supported for the event today and joined by our co-sponsors, ACIL's International Courts and Tribunals Interest Group and the International Organizations Working Group of the European Society of International Law. And just a reminder that today's event will be conducted under the Chatham House rule. And to begin, I'm very pleased to welcome Mohamed Helal, Professor of Law at the Michael E. Moritz College of Law at The Ohio State University. He is also currently Minister Plenipotentiary and Legal Advisor of the Permanent Mission of Egypt to the UN in New York. But he is joining us today, not in that capacity, but as a member, but as the counsel for the League of Arab States during the ICJ's advisory proceedings on the obligations of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in relation to the Occupied Palestinian Territory. Professor Helal is also a member of the African Union Commission on International Law, where he has served as Special Rapporteur for the application of international law in cyberspace and oversaw the drafting of the Common African Position on the application of international law in cyberspace. He is also a member of the Permanent Court of Arbitration. His scholarly work has featured in the European Journal of International Law, Global Constitutionalism, Climate Law, the American Journal of International Law, the Max Planck Yearbook, NYU Journal on International Law, and so on. So many to mention. We're very happy to have you here today, Professor Helal. And just to sort of kick us off, I suppose, what I thought was to start with a very broad and far-reaching question, but please take it in and unpack it in the direction that you want. So to begin with, maybe you could explain what the court decided in its October 2025 advisory opinion, focusing your comments particularly on the privileges and immunities component of that decision.
Yeah, thank you, Fiona. Thank you very much for your generous introduction. And also thank you to both the American and European societies of international law for the invitation and for organizing the panel. It's a pleasure to be here. So, as you mentioned, we're going to focus on the aspects of the advisory opinion that relate to UN law. And the reason I say that is because although the General Assembly referred a single question to the court, in dealing with this question, the court divided its answer or divided the question into two sub-questions. The first sub-question dealt with Israel's obligations as an occupying power, which means that it primarily addressed obligations arising applicable rules of international humanitarian law, but also international human rights law. And the second sub-question, which is what we're going to focus on today, focuses on questions of Israel's obligations as a UN member state. So that's the part of the opinion we're focusing on. It's that second part which relates to Israel's obligations as a UN member state. Now, that part of the opinion is divided into three interrelated sub-issues. And those sub-issues are, first, the permanent responsibility of the UN towards the question of Palestine, and second, the obligations of Israel to cooperate with the UN, which is a matter that relates to the obligations of Israel arising principally from Article 2 of the Charter and other provisions, but primarily Article 2 and specifically Article 2, Paragraph 2 and Article 2, Paragraph 5. And the third sub-issue was the obligations arising for Israel with respect to the privileges and immunities of the UN. So those were the three main issues addressed by the court under the general heading of Israel's obligations as a UN member state. And within the specific question of privileges and immunities, the court addressed three matters, which are the privileges and immunities of UN property, premises, and assets, and the privileges and immunities of UN personnel. And third is the means of addressing concerns by member states relating to privileges and immunities of the UN. So that's sort of the lay of the land. Those are the issues that the court addresses in the opinion. Now, if we look at all these issues, I think the two most interesting parts of the opinion in relation to this issue of what are Israel's obligations as a UN member state, the two most interesting issues that feature in the opinion are, first, the interpretation of Article 2 of the Charter. And what exactly are the obligations incumbent upon Israel, but really incumbent on any member state, pursuant to Article 2? Specifically, as I mentioned, Article 2, Paragraph 2, and Article 2, Paragraph 5. And the second issue, the second interesting issue, which I think deserves a lot of attention and consideration, is the question of the scope and content of the privileges and immunities of UN premises, property, and assets. And specifically, how do these rules relating to privileges and immunities of premises, property, and assets, how do these rules apply in the context of ongoing hostilities? Because, as everybody knows, this is a core issue that has been brought to the fore because of the conflict that began after the attacks of October 7th, which is, how does a belligerent, how does a party to an ongoing armed conflict deal with UN facilities in an occupied territory, and how do you apply UN privileges and immunities in that context? So I think those are the two core, or the two most interesting parts of the opinion, insofar as it relates to Israel's obligations as a UN member state. There's so many other aspects of the opinion that are also incredibly interesting, but as someone who participated in the advisory proceedings, the outcome of the opinion on other issues, such as the privileges and immunities of UN personnel, were, I think, expected. There was the court's answer was consistent with the views expressed by the Secretariat, consistent with the views expressed by the vast majority of states, and consistent with what we assumed, sort of the scholarly community and member states assumed was the scope and content of privileges and immunities, for example, of UN personnel, and so on and so forth. So there are aspects of the opinion that were consistent with what we understood was the scope and content of these rules. But again, just to summarize, those two elements, the interpretation of Article 2 and the application of UN privileges and immunities, specifically as they relate to premises, assets, and property in the context of an armed conflict, were particularly interesting. And I know, hopefully we can discuss these two issues at length, but if, to build on that a little, as relates to Article 2, so the court finds that Israel is under an obligation to cooperate with the UN, and that Israel is also under an obligation not to obstruct the work of UN agencies in the Occupied Palestinian Territory. However, I would say that the court's reasoning was rather laconic. It was brief. The reasoning was not as developed as we would have wanted. And I really like a portion of the declaration appended to the opinion by Judge Charlesworth, where she says, I regret, however, the opacity of the court's reasoning leading to this conclusion. And I completely agree with this. It's a very opaque reasoning. It's, in fact, I would argue there's a lack of reasoning. The court sort of asserts these are the obligations without explaining further. So the court does not provide a robust explanation or interpretation of the scope and content of Articles 2, Paragraph 2, Article 2, Paragraph 2, and Article 2, Paragraph 5, nor does the court outline how the terms of these provisions translate into specific obligations that Israel must fulfill on the ground. And of course, it's fair to assume that the general terms in which this portion of the opinion was drafted reflect the diverging views of the judges of the interpretation of Article 2 and the desire of the court to reach consensus. So that's sort of the general sort of introduction to what happened with Article 2. On the question of privileges and immunities with respect to UN premises, property, and assets, again, the core question is this. What happens if the UN loses control of a building during an armed conflict? Or what happens if a UN property is used by a party to an armed conflict to engage in hostilities? The question is, in that scenario, what kind of protection do UN privileges and immunities provide to these premises, properties, and assets? And to what extent does international humanitarian law, the law relating to the conduct of hostilities, apply in that context? And again, the answer that the court provides is at best unclear. And to summarize it, I think what the court basically said is this. It's up to the UN to determine whether a UN facility is still under UN control. All right, so that's the first step of the reasoning. It's up to the UN to make that determination of whether a facility is still under UN control. But then the court says that this determination creates only a presumption that can be set aside for the most compelling reasons. And the court says that member states have to give considerable weight. See, it says this is a presumption that can only be set aside for the most compelling reason and is to be given the greatest weight by states. And it sort of stops there. So it doesn't really tell us what this presumption, what should a state exactly do with this presumption? And I think we've got to think about it sort of in practical terms. If you are in a kinetic situation where you're actually in an armed conflict, what do you do? Like, do you call the UN Secretariat and do you engage in a conversation? So these are questions, and I think this is something that Judge Tladi picks up on in his declaration that was appended to the judgment. So again, I apologize for the long-winded answer, but to summarize, I think these are the two most interesting elements of the advisory opinion. They're not the only important issues, because the entire opinion is incredibly important. But the two issues that I think have raised the greatest amount of debate in the scholarly community, I think those are two of the more interesting issues. And they relate, again, to the interpretation of Article 2 and the application of UN privileges and immunities in the context of ongoing hostilities. Other issues include the status of Gaza and the approach that the court adopted in determining whether or not Gaza was an occupied territory, and of course, the status of UNRWA. What exactly is UNRWA's role in the occupied Palestinian territory? These are two other issues that the court addressed and that were also really interesting. But again, highlighting these issues is, I don't mean to de-emphasize other aspects of the opinion, which are equally important, but I think those are the issues that I found to be most interesting.
Thank you so much. That's really such a rich way to start. And I just want to jump in for the group and to remind you that our Q&A function is open. So feel free to start sort of popping questions in there as they come into heads, as they're stimulated by the things that Mohamed is bringing to the table. Just to pull on a thread there, I think, as in any decision, it's really important to consider what the court said, but also, as you said, what the court did not say or chose not to go into. Can you
Mhm.
elaborate a little bit further? You touched upon a couple of areas where I think there is a kind of a hold back, potentially, an intentional decision to hold back. Could you, unpack and go a little bit further on that, a number of other areas where you think what is said is important and where what the decisions not to say are particularly important?
Right. So that depends on which issue would you like to start with. Do we start with Article 2 or do you want to start with privileges and immunities? You tell me. We can go in either direction.
Let's start with Article 2.
Mhm. Yeah. So Article 2. So Article 2 is very interesting. What's really interesting is what is in the opinion, but also the great debate that you see playing out between the judges in their separate opinions, partially dissenting opinions, and declarations appended to the opinion. But before looking at the separate opinions, I think it would be important to look closely at what the opinion says to determine exactly what the court says. And the reason I say that is because by looking at the separate opinions, one might get the impression that the debate on the interpretation of Article 2, and specifically Article 2.5, was framed in binary terms. And what I mean by binary terms, it's this. One may get the impression that there are two camps, and it's either that Article 2.5 generates binding obligations to give every assistance to the UN only when such action is taken pursuant to Security Council resolutions. So that's one camp that basically saying Article 2.5 generates binding obligations only if we're talking about a UN Security Council resolution adopted under Chapter 7, or that obligations under Article 2.5 are not limited to Security Council resolutions. So if you only look at the opinions, you may get that impression, but I don't think that the debate should be viewed in such binary terms.
Hmm.
Rather, I think there is a spectrum of obligations, various forms of obligations that are generated by the combination of Articles 2, paragraph 2, and Articles 2, paragraph 5. And I think you see that if we look closely to paragraphs 176, 177, 178, and 179 of the opinion. In those paragraphs, the court determined the following. The court said that Israel is not entitled to withhold its cooperation with the United Nations by unilaterally deciding on the presence and activities of the United Nations in the occupied territory. The court also indicated that Israel may not obstruct the functions of the United Nations. And it also said that Israel must provide every assistance in action taken by the organization. So if we look at these paragraphs, if we look at these phrases, we have a bunch of operative phrases. These operative phrases are not entitled to withhold, that Israel may not unilaterally decide, that it must provide every assistance. In my view, these terms employed by the court are terms of legal obligation. These are not oratory terms. These are not exhorting or encouraging Israel to behave in a particular way. Rather, they indicate legal obligation. The question is, though, what is the source of these legal obligations? Where are these legal obligations flowing from? And here is where the court is unclear. Here is where the opinion itself is unclear. Ultimately, it appears to me that the court cites four provisions from the Charter, namely Articles 2.2, 2.5, 55, and 56. In addition to the general concept of the permanent responsibility of the UN for the question of Palestine. And it bundles these provisions and the permanent responsibility together as a basis for its conclusion. But the court does not explain with any clarity what is exactly the scope and content of Articles 2.2 and 2.5, nor does it clarify which of these specific provisions is generating these specific obligations for Israel, right? In other words, the court doesn't really tell us which provisions are doing what work, right?
Yeah.
What provisions are generating which kinds of obligations. So that's sort of what I think is happening in the opinion, and I think the court does that. This ambiguity is the result of the desire to achieve consensus between the judges. Now, having said that, again, what I think the main takeaway from this aspect of the opinion, and I'm going to move to the separate opinions and the declarations now, what I find most important is this, is that the court does not take the position, all right? It does not take the position that Article 2, Paragraph 5 generates obligations only with respect to Chapter 7 resolutions adopted by the UN Security Council. It doesn't say that. And also, the court says that Israel has specific obligations. It must not obstruct. It must facilitate. It cannot unilaterally decide. And none of these obligations come from Security Council resolutions. So, for instance, if we talk about UNRWA, none of UNRWA's operations are based on Security Council resolutions. And so the fact that the court explicitly says, so if you look at paragraphs 177 and 179, the court says, under these provisions, including with respect to UNRWA's operations, Israel is under an obligation not to obstruct. That obligation, so UNRWA's operations are not based on Security Council resolutions. So the fact that the court sort of frames its position that way, I think, does indicate that the court is not of the view that Article 2.5 generates an obligation to give assistance to the UN only in the context of applying UN Security Council resolutions. I do not think that that is the case. And I think that if we look at the judge's opinions, I think that sort of it bears out. So there's a spectrum of views, clearly. I think on one side, you have Judges Cleveland and Abraham, who in their joint declaration take the most restrictive view of Article 2, Paragraph 5. And I think on the other side of the spectrum, you have Judge Gomez Robledo, who adopts maybe the most expansive interpretation of Article 2, Paragraph 5, with maybe Judges Cleveland and Shui sort of occupying the middle ground. In my view, there is a spectrum, definitely, in the views, but I don't know if the views are as diverging as they appear on first, sort of prima facie, or sort of in first blush. And the reason is this. If we look closely if we read these separate opinions and declarations closely, even Judges Cleveland and Abraham do not take the view that Israel's obligations with respect to the presence of the UN emanate exclusively from UN Security Council resolutions. And I think there's a little bit of a paradox in the joint declaration by Judges Abraham and Cleveland. So both judges clearly say this, that the term any action in Article 2, Paragraph 5 means legally binding action. And the term legally binding action applies to what they call a narrowly circumscribed set of actions by UN organs, in particular, those based on decisions of the Security Council under Chapter 7. So they take that position very clearly. But then if we read a little further in the opinion, they say the following. They acknowledge that UNRWA's role in the OPT is crucial. And then they also note that the UN cannot carry out its mandate in the OPT, including through UNRWA, without having access to the Palestinian population. And accordingly, they say, Israel is under an obligation not to obstruct the access of UNRWA to the Palestinian population. And this may require traversing the territory of Israel. And again, here's where I think there's a little bit of a paradox, is because UNRWA's mandate is not based on a Security Council resolution. And so the two judges that adopt a narrower understanding of Article 2, Paragraph 5 admit that there is an obligation not to obstruct such access, including in situations or in cases where the mandate does not emanate from an article from a Chapter 7 resolution by the Security Council. So what I'm saying is that even if you adopt a narrow, strict interpretation of Article 2, Paragraph 5, it appears that the obligation to cooperate with the UN under Article 2, Paragraph 2, and the obligation to give every assistance to UN action under Article 2, Paragraph 5 is not necessarily exclusively limited to action undertaken pursuant to Chapter 7 resolutions adopted by the Security Council. So that's one part of the spectrum. Now, in the middle, let me go to the other side of the spectrum, which is Judge Gomez Robledo. And Judge Gomez Robledo adopts, I think, a very progressive view where he basically, he describes the major internal discrepancy in the court's reasoning, and he talks about the extensive duty to cooperate. And what I find interesting is that this is paragraph 8 of his opinion, and at the very bottom he says this. He says that the United Nations synthesizes the civitas maxima ideal, the ultimate source of international law. And I hear that, and to me, it sounds something close to sort of a natural law approach to interpreting the Charter. And you see that, so that to me is the other side of the spectrum, where you have a narrow, a restrictive understanding of Article 2.5 versus a much broader understanding of the Charter, a much broader interpretive methodology that almost leans on natural law. In my personal view, I find the most compelling approach was the one adopted by Judge Charlesworth. And Judge Charlesworth, who's sort of sitting in the middle of the spectrum, what she says is this. She argues that non-binding resolutions of the General Assembly cannot be transformed into legally binding obligations pursuant to Article 2.5. And I think that's absolutely correct. We cannot use Article 2, Paragraph 5 as a vehicle to transform what everybody recognizes are non-binding resolutions of the General Assembly into legally binding obligations. Adopting that argument would be wrong. But, and this is what I think is really compelling about Judge Charlesworth's approach, she says the concept of giving every assistance, that phrase in Article 2, Paragraph 5, should not be equated to an obligation to comply. But that obligation is better understood as an obligation of good faith cooperation. It's not necessarily an obligation to comply with resolutions, but it doesn't mean that you are in a legal vacuum, that you are completely unbound by any commitment to the UN. And the way that Judge Charlesworth frames it, I think, is very useful, where she calls it an obligation of good faith cooperation. And she says, on that basis, the obligation is not to obstruct the work of the UN, including permitting the UN to traverse the territory of Israel. And I think that understanding of Article 2.5 is a useful and constructive approach of understanding it. But I think we need to take a step further. And that's really the following. We need to think of Article 2.5 and the way that it applies to Israel in this context in the broader circumstances of the opinion. And specifically this, I think the court missed an opportunity to clarify how the combined effect of, first, the permanent responsibility of the UN for the question of Palestine. Second, the illegality of Israel's presence in the occupied Palestinian territory, and the right to self-determination of the Palestinian people, and Israel's obligation not to obstruct the exercise of the right to self-determination, how those elements all play into the interpretation of Article 2.5. Because Article 2.5 is not operating in a legal vacuum, but rather it intersects with other legal obligations that are incumbent on Israel. In other words, what I'm saying is this. Because the UN has a permanent responsibility to the question of Palestine. And because Israel's presence in the OPT is unlawful, and because Israel has an obligation not to obstruct the exercise of the right to self-determination, because of all of these considerations, it also has an obligation to give every assistance to the UN in its discharge of its permanent responsibility for the question of Palestine, in the discharge by the UN of its obligations to facilitate the exercise of the right to self-determination. And I think that is an element that the court should have. It sort of provided more clarity on how those elements, which it touches upon in the opinion, how those elements bear on the application of Article 2.5 in this particular context.
That's so interesting because you've also taken us down a number of kind of different interpretive pathways there, the different streams of thought. But can I take you to, I guess, a very practical question, which is, does the advisory opinion provide any clear difference to how the UN should think about its day-to-day operations in the OPT?
Well, I would say we should direct that question to UN officials and maybe not to myself. But if I were working for the UN, I think two takeaways. First and foremost, keep calm and carry on. Because the way I see it is that the court largely, if you read the written submission presented by the UN Secretariat to the court, and you compare that to the outcomes of the opinion, they're largely consistent with each other. Not entirely identical, but largely consistent with each other. So that tells me that on the whole, the court agrees with the Secretariat's understanding of its own rights and obligations. And so that would be the first thing I would say, that if you're the UN, you continue to apply your understanding of the rights and obligations as outlined in the opinion. The second point is to continue to engage with concerns expressed by member states, including Israel. If I were the UN, I would continue to take very seriously concerns expressed by Israel and to continue to invite Israel to avail itself of the paths to address concerns relating to UN activities in the Occupied Palestinian Territory. And those avenues are found in the General Convention and other administrative processes within the UN. In fact, if you look in the opinion, and this was also touched upon by Judge Claudy, in paragraph 212, basically the court says, any concern of alleged abuse raised by a member state regarding the United Nations or its personnel must be addressed within the existing legal framework for the settlement of differences. So again, that's why I'm saying keep calm and carry on, is that the UN would invite any member state, but particularly Israel, if it has concerns, is to avail itself of those options that are available in the General Convention and other administrative processes within the UN architecture and sort of within the bureaucracy.
Mm-hmm, mm-hmm. I'm going to start weaving in a number of the questions that we're getting from the participants here. And one of them goes back to something you've already touched upon, the rule on the abuse of premises argument. And what Dan Asalia asks is, did the court find that the host state, Israel, has a right to override the inviolability of UN premises if there is credible evidence that that premises is being used for activities outside of Article 2 mandate, such as military or terrorist use? Or did the court rule that inviolability remains absolute regardless of how the building is misused? And this is a little bit that hypothetical that you were posing earlier, that situation of, in the kinetic moment, how does this play out?
Yeah, so that's an excellent question. It's an opportunity to address that issue with a little bit more detail. So first and foremost, it's important not to describe Israel in this context as, quote, the host state, because, and sort of this is the point of departure in thinking about Israel's obligations with respect to UN presence in the OPT. So the point of departure is that Israel has no sovereignty over the OPT, over the Occupied Palestinian Territory. And second, another point of departure, which interconnected, is that Israel's presence in the OPT, including East Jerusalem, is unlawful. And so because that is the point of departure, Israel, and I think this is a point of consensus among the judges, even, judges Abraham and Cleveland clearly indicate that Israel has no right, if I were to read from their joint opinion, Israel is not obligated to consent to the establishment of a United Nations office within its sovereign territory. But that does not apply to the occupied Palestinian territory because that is not its sovereign territory. So to start off with, the correct designation of Israel in this case would be that it is the occupying power as opposed to the host state. And by virtue of being the occupying power, Israel does not have the right to unilaterally decide on UN presence and activities in the occupied Palestinian territory. So that's the point of departure. The second thing that I think is very interesting as relates to how do we apply UN privileges and immunities, including in relation to premises and facilities. So in paragraph 186, the court says something I think very interesting. It says, Article 105 of the Charter, which relates to the immunities of the organization, and the General Convention, which is the General Convention on Privileges and Immunities, do not cease to operate in the context of armed conflict. Why is this interesting? What I find interesting here, and it goes back, Fiona, to your original question, as to what the court is not saying. What I think is a really important takeaway from the opinion is that the court did not interrogate the question of whether the law of the conduct of hostilities is a lex specialis in relation to UN privileges and immunities. So let me unpack that a little. I think before the advisory opinion was delivered, and as many parties were preparing their submissions to the court, there was a question of what is the primary applicable law during ongoing hostilities in relation to UN premises and facilities? Is the primary applicable law, in other words, is the applicable lex specialis UN privileges and immunities, or is it the law on the conduct of hostilities? In other words, is it UN law or IHL? Is a combatant, is a party to a conflict bound to apply UN privileges and immunities or the law of armed conflict? And because here there's a discrepancy between the two bodies of law. The two bodies of law place different types of restrictions on parties to an armed conflict. And so the fact that the framework that the court applies is exclusively UN privileges and immunities, I think is really notable. The court does not even entertain the question of whether the law, the conduct of hostilities is applicable in this case. And I think, in all fairness, I think there would have been a compelling case to argue that the applicable law, in addition or in parallel with UN privileges and immunities, is the law of armed conflict. And the court does not go there, nor do the judges. And so I think that is a really important takeaway. But then the question is, and the question that you're asking, and also the question from the audience is, well, what happens if a UN facility is taken over by a party to an armed conflict, or by an armed group, or by a terrorist group? And I think paragraph 196, so everyone in the audience, I think maybe should go back and read or reread paragraph 196 and try to unpack it. And my personal view is the court does not give us definitive guidance. The court does not provide combatants, it does not provide belligerents, it does not provide parties to a conflict with clear operational guidance on what to do in this context. So what exactly, and I sort of alluded to it in the introduction, what exactly does the court say? It starts off by saying, look, the general principle is that the inviolability of UN premises and the obligation of non-interference with UN facilities are essential. These rules, non-interference and inviolability, are essential to safeguarding the effective and independent performance of the functions of the organization. Fine, that's a great general principle. But then the court says, this principle, applying these rules in the context of an armed conflict, raises challenges. And obviously, these challenges are sort of the scenarios we're talking about, where the UN, in an ongoing kinetic situation, loses control of a building, or if an armed group enters a building or takes control of a building. What do we do then? Again, the court proposes two steps. First, it says it's up to the UN. It's up to the UN to make the determination as to whether that particular facility is still under UN control. And then second, it says this determination creates a presumption that may only be set aside for the most compelling reasons, and it must be given the greatest weight for states. And it's interesting that the court cites, it cites to support this statement the previous advisory opinion relating to the immunity from legal process of a special rapporteur. It's the advisory opinion from 1999. Interestingly, however, that opinion did not relate to the inviolabilities of premises, assets, or buildings. It related to the immunity of an individual, and the immunity of UN personnel from legal process. So, citing that opinion to reach that conclusion, I think, again, I'm not certain that citation provides complete support to that assertion by the court. And then the court says this: if UN facilities, if UN premises and property are damaged as a result of military activities, this may amount to a violation of obligations under the General Convention. So you can sense a degree of equivocation. Now, why do I think this is really important? Because if you look at the written submission presented by the UN Secretariat, the terms they used are that the inviolability of UN premises and assets and property is absolute. Absolute is the term used by the UN Secretariat. If you look at paragraph 196, the language and terms used do not sound like they're absolute. So there's definitely some room there for, in a kinetic situation, for a combatant, for a party to an armed conflict to basically argue, it is our view that this property is no longer under the control of the UN. But where there is a degree of ambiguity is, what do you do operationally, especially in a kinetic situation? And I think Judge Claudy picks up on this. And Judge Claudy basically says, look, I agree with the outcome. I agree with the general approach adopted by the court. But then Judge Claudy says that the way that paragraph 196 is framed could create a loophole that states may use in order to justify attacks against the UN. And, I'm just going to, I just read Judge Claudy's words. He says he's prepared to accept the correctness, but these qualifiers, right, these qualifiers taken out of context are liable to create a misunderstanding as to the scope of the state's obligations. It is important to ensure that these comments are not seen as providing a right of autodetermination by states to escape from obligations owed to the organization. And so I think there is going to be debate as to how this paragraph 196, applies in the context of a kinetic situation. What exactly does a party to an armed conflict do? If I were a military lawyer, if I were in the field, I think the way to apply paragraph 196 would be for a party to an armed conflict that suspects, that has evidence, that has information indicating that a UN facility is no longer under the control of the UN, is basically to inform the UN and to invite the UN to respond as fast as possible to concerns relating to the possible loss of control of that facility. And as the court indicates, to give the greatest weight to the views expressed by the UN and not to set aside that determination unless there is clear evidence, right? Unless there's clear evidence that that facility is being used in a manner that is inconsistent with its function. And in that context, honestly, if a party to a conflict uses force, if it is, again, if it makes sure that it informs the UN, if it invites the UN to confirm its determination, I think that would be one way to apply the findings in paragraph 196. And again, what I find, again, very important is what the court does not say. So for instance, the court does not doesn't address, it doesn't take into consideration Article 8 of the ICC statute, which indicates that it is not a war crime to engage or to target or to damage a UN facility that has lost its designation as a civilian object. Very, very important. I think it's really interesting that the court did not go there, that the court did not address that question. And so that, to me, indicates that privileges and immunities continues to apply, but that the court is not entirely oblivious to the very real challenges that arise in a kinetic situation.
Thank you. Yeah, indeed. Another place where it's really the absence rather than including the presence. A question here now coming from one of our colleagues at the European Society of International Law, Lorenzo Gaspari, asks, concerning paragraph 209 and the reference to Israel's obligation under Article 105 of the Charter, and the General Convention to ensure the safety and security of United Nations officials and experts on mission, do jurisdictional immunities cover safety and security? Article 105 and the General Convention do not refer to safety and security, which is also a UN responsibility towards its staff. So taking us in the direction now of more of personnel.
Yeah, no, I think honestly that portion of the opinion on the privileges and immunities of UN personnel is entirely it was entirely consistent with what it was entirely consistent with traditional understandings of those rules. So the immunity from legal process, the preserving the freedom of movement of UN personnel within Israel in order to traverse the territory of Israel and to reach the occupied territory. So the short answer is those portions of the opinion that relate to the immunities of UN personnel, including immunity from legal process, so including jurisdictional immunities, were entirely consistent with established understandings and interpretations, both of Article 105 and the General Convention. So it includes, paragraph 103 tells you this includes immunity from personal arrest, immunity from detention, immunity from seizure, immunity with respect to words, spoken, written acts, immunity from legal process. So I think the opinion on that front is entirely uncontroversial and is based on and just entirely reflective with established understandings of the scope and content of the General Convention and Article 105.
Okay. We have another question here coming from an anonymous attendee in this case, asking whether, in your view, the opinion establishes a positive obligation for the international organization to police its own premises. Specifically, if the UN fails to prevent its facilities from being used by combatants, does that failure constitute a breach of the headquarters agreement that justifies a countermeasure?
Right. So that's a very interesting. So this is an excellent question. I thank the anonymous attendee. And I want to pick up on that last part of the question about countermeasures, because and again, this is not in the opinion, and maybe this is the subject of a law review article, but if I were to put my shoes, if I were to put myself in the shoes of a party to an armed conflict, and if we are in a situation where a threat or sort of an armed group has taken control of a UN facility or any other civilian object, but if they've taken control of a UN facility, one approach to think about it is to think about circumstances precluding wrongfulness, right? So let's assume that a party to an armed conflict, Israel or any other party to an armed conflict, because I think we need to think of this opinion not only as just applying to Israel or to the Occupied Palestinian Territory, but it's also a contribution to our understanding of how this law operates in all different theaters of operation or just other areas. So let's assume that a party to an armed conflict is faced with a situation where they are faced with a threat from a UN facility. And let's assume again that the UN, there's a question about the determination of whether the UN continues to exercise control over this facility. So one path is to sort of the path that I previously described, where the party to an armed conflict sort of raises the matter with the UN, inquires with the UN whether the facility remains under its control, requests the UN to ensure that this facility is not being used for unlawful purposes. But let's assume that the party to an armed conflict finds itself in a position where it is facing a threat from that facility. I think there's a plausible argument to be made that if that party engages that facility in the exercise of the right to self-defense, it could invoke circumstances precluding wrongfulness in that context. But if the state does that, we must not lose sight of that it would be a wrongful act. So it would still constitute an internationally wrongful act to engage a UN facility inconsistent with the UN's determination. So if the United Nations confirms that this is a facility under UN control and that it is not being used for unlawful purposes, the rules relating to circumstances precluding wrongfulness continue to apply. One of which is self-defense, and another is necessity. Right. So I think we need to explore. And to be absolutely honest, I've seen some scholarly writing on this issue, but I think it is a plausible argument to be made. I don't think countermeasures well, I mean, it's not wrong. You can take countermeasures, but in the context of a kinetic situation, you can't take countermeasures as might not be the right ground to invoke because you're not permitted to engage in countermeasures involving the use of force. But self-defense is one of the circumstances precluding wrongfulness. And so I think one question to explore is how circumstances precluding wrongfulness apply in this particular situation, which I think the question is sort of touching upon by referring to countermeasures.
I'm going to broaden out. Thank you so much for that. I'm going to broaden out, and this is optional because we had the focus today was much more on privileges and immunities. But seeing as I have quite a few questions here on starvation as a crime, I'll take the opportunity to throw one of these questions in there. And again, you can kind of make your decision based on the parameters that we'd set for today. So Saif Ali asks, says that they're currently working on starvation as a crime as part of their dissertation. They note that pursuant to that, building on Article 2.5 of the UN Charter, could the obstruction of UN humanitarian operations, where starvation is a foreseeable consequence, be understood not merely as a failure to facilitate aid, but as a positive breach of the Charter itself, thereby strengthening arguments for international responsibility, even absent proof of specific intent?
Look, the short answer is possibly. But I mean, if thinking of someone who's working on a dissertation, my answer would be the strongest arguments with relation to starvation are the provisions of Additional Protocol 1. And so I don't think that it is necessary to try to squeeze out of Article 2, Paragraph 5, an obligation relating to the prohibition of starvation. The prohibition of starvation, the prohibition of targeting, of not depriving a population of um, items necessary for the survival of the population is an established rule of customary international law. It's an established rule of humanitarian law. I don't think that involving Article 2, Paragraph 5 would necessarily strengthen the argument. The rules are established, they're uncontroversial, incontrovertibly applicable in this context, where I don't think that adding or trying to bolster the argument by referring to Article 2.5, I don't think that's necessary. I always, sometimes when I tell students that I supervise is, just take this a straight and direct line from issue to rule. There's no reason to add additional rules that don't necessarily do too much work. With starvation, the rules are so clear, so yeah, like in this particular case with Gaza, so applicable. The evidence is so overwhelming that I don't think it's necessary to refer to Article 2.5. I don't think Article 2.5 would contribute much to an argument. If anything, maybe Articles 55 and 56 that relate to basic human rights may be more relevant.
Yeah, yeah. We have time for just one final question. So I'm going to shoot in question from Giada. And that's assuming that Article 2, Paragraph 2 and Article 2.5 would entail a legal obligation for Israel. And in the moment Israel does not respect those provisions, is there any action that could be taken in order to enforce those obligations?
Well, it depends on how you define action, but I mean, recourse to the UN Security Council is, of course, always available. Not necessarily, it may not yield the desired results, but such is the case really with virtually all UN provisions, right? The principal enforcement mechanism is to go through the Security Council. However, in addition, of course, you do have other paths like an emergency special session in the General Assembly, but also I think it's important not to lose sight of the value of other methods, not necessarily of enforcement, sort of understood as hard enforcement, but the normative environment, building a case, building a historical record of breaches or perceived breaches of the Charter and broadly international law is very valuable. So, for instance, this very advisory opinion was the subject of a UN General Assembly resolution that was adopted just last week. Skeptics may argue that that is, it has maybe some value, but it's not necessarily effective. It does not provide immediate and effective protection to civilians in the occupied territory. And I think that skeptical view is correct, and there's definitely a protection gap, but I don't think it's without value. I don't think it is without that is completely devoid of any value to adopt a resolution in the General Assembly that is based on the opinion and that reaffirms the obligations of the occupying power with respect to the civilian population. And by the way, even including sort of the previous question on starvation and questions of also forced displacement. So continuing to reaffirm and continuing to reaffirm these principles, continuing to bolster the normative environment surrounding these issues is valuable in and of itself, even if we do not have clear paths to hard enforcement.
Thank you so much. And with that, I think we're reaching the end of our hour together. Thank you so much, Professor Halal. Thank you because this is so rich, so current, so complicated, and that you've laid this out with such grace and clarity, and I think really brought the opinion to life in a way that all of our individual readings and discussions, it brings it to a whole new level. Thank you so much. please, to those attending, watch this space. This is just, as I said, the first of a series of mini panels that aim to be really bringing current topics for international organizations to the fore for discussion. So watch out for emails from Duncan, Ashrita, and I as we continue to organize these. There'll be one in the new year soon advertised. And thanks so much to all for participating, for the very lively questions